Hello, good evening everybody. Maayong buntag sa Philippines. Good morning to you and good evening here in the United States. I'm Nick Caracal. I would want to share with you understanding exceptional hardship waivers. This is actually geared towards sa mga teachers natin who are actually on a J1 visa. And as we all know, J1 visa teachers subject to the 212E needs to go home to the Philippines or to their last home country of residence before they obtain their J1 visa, before they will be able to obtain a green card or apply for other non-immigrant visa. But we will go through that as to the details of that. For now, I just want to have a sense of whether or not my volume is okay. If you can actually just give me feedback kung okay lang ako. So, hello Ma'am Gina, Ma'am Mary Grace, Ma'am Elaine, good evening po. So again, as usual, kung may mga tanong kayo, please make sure that you actually write them in a comment and I will try to respond to them as we go through the exercise. Okay? I only have 16 slides. So this is geared towards exceptional hardship. So we're gonna go over that in a bit. Sorry, Ma'am, thank you, Ma'am Melody, for giving me feedback. So okay na tayo, no? So we're gonna start. I'm gonna be sharing my screen with you guys. So para mas maintindihan nyo at mababasa nyo ang aking presentation. So again, exceptional hardship to, which generally applies for people who are J1 visa holders subject to the 212E. So may ibang klaseng waivers we call the extreme hardship. It's a different level of hardship, but more or less it's the same argument and it's the same content with regards to application, filing the application to USCIS. So we'll go through the next slide now. I would just like to give a disclaimer. This material is for presentation purposes. If you have questions, I will try to answer them generally speaking. But if I would be able to speak on your case, do not take this as a specific advice to you. So it is, my presentation now does not create an attorney-client relationship. So we've been doing very well in terms of waivers. We've been getting approvals and we're receiving so far less than 10 RFEs for over almost hundreds that we've submitted. So that's why I feel it fitting to just share with you how we handle or kung paano namin ginagawa yung mga exceptional hardship. No? So alam ko na people would have the tendency to do it on their own. But I've seen a lot of denials for people who came to me na nagpapatulong kasi they've been denied. The problem with the waivers though is you can only use one ground once. So once you are denied, you cannot use again the same ground because again, generally there's no mode of appeal for, there is a mode of appeal for this type of waivers, but as much as possible, if you can avoid that, then avoid that, no? So again, my presentation today is just to give you a glimpse of how exceptional waivers are being done, hoping that if you would decide to do it on your own, mayroon kayong idea. Or even if you're gonna hire a lawyer, may idea kayo kung anong ginagawa ng lawyer and why is it very important that you will be engaged in the conversation. So, in doing these waivers though, dapat talagang mag-work closely or coordinate closely yung client at saka attorney. The attorney cannot do it themselves. No, they have to understand fully what the background of the client, kung ano yung saan mo huhugutin, yung arguments mo, anong sitwasyon nila. And on the same time, hindi pwedeng yung papakinggan lang natin yung client because again, at the end of the day, there are rules and regulations that you need to comply and to have to follow. So that's why very important na yung relationship ng lawyer at saka yung client is very closely coordinated kung ano man ang strategy nila. Okay, so going back to the legal basis of the J1 waivers, this is actually the Immigration Nationality Act 212E, which says that no person shall be eligible for immigrant visa or permanent residence or apply for another non-immigrant visa if they are subject to the 212E unless they have complied to the 2-year home residency requirement. So ang ibig sabihin nun, pag J1 visa holder ka and you're subject to the 212E na provision ng Immigration Nationality Act, then you will be given initially 3 years initial stay in the United States. Then after that, you may be eligible for an additional 2 years. Then after that 2 years, maximum 5 years, you need to go back to your home country and stay there for 2 years with the intention of that of you being able to share kung ano mang natutunan mo whatever skills and experience you have had during the last 5 years, that you go back to the Philippines and impart those knowledge and experiences to the Filipino students. So yun basically yung purpose ng J1 visa exchange visitor program. Okay? But there are exceptions to that. And of course, there's a lot of basis or grounds for waivers. But for this, for tonight, ang pag-usapan lang natin are yung exceptional hardship. So, if the primary J1 applicant is subject to these restrictions, it also means that generally yung mga dependents nila, asawa nila, mga anak nila, will be applied to the same restriction. So, karamihan sa inyo, pag you are subject to the 2-year home residency requirement, yung asawa niyo, yung anak niyo are also subject to the 212 home residency requirement. Though may mga cases where the J1 applicant is not subject to, but yung dependents nila subject to, or vice versa, no? So, yung mga dependents naman ang hindi, yung J1 ang meron. But again, normally, you're gonna ask for advisory opinion with the Department of State or with the reviewing officer. They would actually ask for a secondary opinion. But generally, each case is different, so I would recommend that you talk to your lawyer kung sino nag-handle sa case niya, what is the best strategy for you. Okay, so pag-usapan natin ngayon, ano bang mga applicable waivers. So the Department of Homeland Security actually established this basis of waivers. Number 1, no objection statement. Ito yung pinakamadali, ito yung pinaka-easy, ito yung pinaka-fast, ito yung pinaka-mura. And most people will actually handle this type of application. They will apply it to the Philippine exchange visitor program. This is being managed by the CFO, but of course it's being decided by the EVP committee. So as of now, they are actually granting automatic waivers for people who actually had a U.S. citizen child, or if they are actually married to a U.S. citizen. But pag-usapan natin ang details na yan. So that's what we call the no objection statement. In some professions, they are so-called the IJA waivers. This is a request by the interested government agency. For the purposes of mga teachers, ang applicable dito is the Department of Education in the United States. So sila ang mag-grant ng waivers na yun. And this is interesting though, because earlier, I think 2 years ago, they actually posted that they are not accepting applications for IJA waivers now for J1. But last month, when we actually inquired and somebody actually gave us a hint that it's already been archived, we've been trying to contact them, but no one is responding. Their website is saying that you have to contact the Bureau of Post-Secondary Education. We try to contact them, but again, no response yet. But it will be good, no, if they are now starting to accept IJA waivers by the Department of Education, kasi that will be another option or hope sa mga teachers na walang anak na US citizen or hindi nag-asawa ng US citizen or green card holder. The third ground is persecution, but I will not dwell on that one. But again, ang pag-uusapan natin ngayon is number 4, exceptional hardship to a US citizen or green card holder spouse or child of an exchange visitor. The other one, number 5, applies to physicians. So we are not going to talk about that. Hi, Ma'am Bain Williams. Good evening, attorney. What is the current timeline for the exceptional hardship waiver from 612 to release a final decision? So pag-usapan natin mamaya yan kung what will be the timeline of these exceptional hardship waivers. Nabanggit ko kanina, no objection statement. So under the Philippine EVP program, you may be able to have an automatic grant of no objection statement from the Philippine government. Unfortunately, the NOS program has been suspended now, and there is no definite time when they will be able to start accepting NOS applications. So the general rule nila, sinabi nila is, once you are married to a U.S. citizen or a green card holder or you have a U.S. citizen child, once you apply the no objection statement, they will automatically grant the no objection statement waiver. So generally, the timeline for this is 1 to 3 months depending on when the transmission period nila, pag natanggap nila application mo, ni-review nila, papadala nila sa Washington DC. Washington DC personnel will forward it to the review board, and then it will be forwarded to USCIS, then you get your waiver. So generally, nasa mga 1 month to 3 months yan. But with the pandemic, it has been suspended. We don't know what the timeline is, kung kailan nila tatanggap ulit. Though, ang some of our clients now, we are starting to prepare the applications, hoping that when the AVP says, oh, we are now accepting applications, we can actually file it the day after. Okay? Yung mga religious workers, ailing relative members, I actually have a different video for that. So if you would want to see, you can visit my YouTube channel, and then you can actually look into other waivers. But as soon as the EVP starts opening again or accepting the NOS, I would plan to have another Facebook Live just to talk about the EVP grounds for granting no objection statement waivers. Okay, but for now, this is the general rule. Again, if you are married to a U.S. citizen or a green card holder, or you have a U.S. citizen child, you might be able to apply for the no objection statement. However, even if you are married to a U.S. citizen or a green card holder, but you are formerly married in the Philippines, and then nag-divorce ka in the U.S. or nag-divorce ka in Hong Kong, right? And we know very well that foreign divorces, generally speaking, is not recognized in the Philippines unless you would apply for the recognition of foreign divorces elsewhere. You will not be able or will not be eligible for no objection statements. So in this case, your only remedy, if you would be able to apply for H-1B or apply for a green card, is to apply for the exceptional hardship waivers. And that's the reason why ito yung topic natin ngayon kasi it's a little bit exceptionally hard to prepare these waivers as well. So, mas maganda na rin naintindihan nyo. So, general concepts, it is under the discretion of the reviewing officer pag nag-apply ka ng exceptional hardship. So, it's not a matter of right that you could demand that your application will be approved. So, it really depends on a case-to-case basis on how strong the arguments you could provide, no? So, mga clients kami na nagko-consult sa akin and they would ask me that, hey, what do you think is our chance of approval? So, of course, I have my own criteria in my mind of whether or not I would accept the case, because until now, I will not accept a case if I believe that they are not deserving of an approval. So, I have that ability to at least assess initially. But kung kunwari sa tingin ko strong naman yung case, then I would accept the case initially. Then after that, we will have another 1-hour session just to go through over the exceptional hardship questionnaire. It's about 18 pages, no? So we will go over all the factors that need to be considered. And then after that 1-hour session, I would be able to summarize up with the client to say, hey, we have a strong argument because of these reasons. So yun yung ginagawa namin. Processing time, normally once you apply for or you submitted your 612 application for the waiver, it's about 7 months to 12 months nowadays. Though before the pandemic, normally they would be able to give an approval within the 7 months to 9 months time frame. Once you have that approved in the 612, it will be forwarded to the waiver review division. And then after a month, you will receive the official approval of the 612. So ganun siya tagal, but more or less, alam mo kung ano yung timeline. But nowadays, it's really different daw. It will be handled by California Service Center. And then after that, again, you will be lucky if you will be approved. So for you, what does that mean if you are approved? It only means that it opened doors for you. Hindi ka na uuwi sa home country mo, hindi ka na uuwi sa Pilipinas. And if you have an employer that will offer you H-1B or will offer you a green card option, then you can grab those opportunities. Okay? And then applicant's hardship is irrelevant. So the sad reality though is some people think that at the moment that they apply for exceptional hardship, they start talking about their own hardship. No? So ito yung non-US citizen that, hey, it will be hard for me if I will go home to the Philippines because may mga anak ako lang yung breadwinner, and so on and so forth. But no, guys, it doesn't matter because your hardship is irrelevant as far as the waivers is concerned. So pag-usapan natin mamaya anong minimum requirement. So marami lang mga nagtatanong dito. I will just answer maybe 3 questions then. Hi, Ma'am Bain. Yeah, I think I've already answered that question. So generally, it will take about 7 to 9 months. Then after you have an approval, it will be forwarded to USCIS. And then in a month, you will receive your 612 approval notice. From Sir Jude, I'm wondering if we can also apply a J1 for our child currently waiting for petition for immigrating. Boss, yung J1, you could normally search for a J1 agency. But I think we still have a chance that once the suspension is suspended after March 31, that we may still be able to argue the exception, the CSPA. So let's just wait for that. Sir Jenica, Ma'am Jenica, hello po. Ang visa ng J2s ko po ay not subject to the 2-year home residence requirement. ano po ang sitwasyon pag ang company nila dito sa US. Ma'am, I would recommend that you would consult, no? Because there are really cases where pag walang tatak na subject sila to the 212E and after an opinion from the Department of State that it really is, they are, hindi talaga sila subject to the 212E. So normally you have two options there. Either you could take the risk filing the H1B and then you hope that you will not receive an RFE, or you could actually ask for an advisory opinion whether or not your dependents are subject to the 212E. But I would recommend that you consult a lawyer to really dig into your case. Sir Mark, good evening attorney. Pwede naman kami diretso exceptional hardship kahit hindi na kami dumaan ng NOS, di po ba? Same reason na may anak sa US citizen. Yes, dahil nga, sinabi ko kanina, pinakamabilis, pinakamadali, pinakamurang way of getting your waiver is through the no objection statement. But if you are already in your 5th year and your visa will expire in the next 6 months or 7 months, then it might be worth it to file for the exceptional hardship based on the US citizen child. What I would recommend is that you talk to a lawyer para alam nyo kung you have an argument for exceptional hardship based on the child. So that would be my advice to you, Sir Mark. Ma'am Rosemary, attorney, sana po susunod meron naman po kayo discussion solely for not subject to the 24 teachers. Ma'am, kung hindi ka subject to the 212E, then it's you have a better life. You can smile now because you don't need this, right? It only means but that if you are not subject to the 212E and if your employer will offer you an H1B or a green card application, then grab it. You don't have to worry about all these things. So, kaya sinasabi natin na this is really for the people subject to the 212E kasi the purpose of them getting a waiver is para maging kapareho sila ng position for people who are not subject to the 212E. I hope that answered my question. Yes, Sir Mark, just send me a message or send a message to I Dream America so we could actually set up a formal consultation. So, the filing process, kasi may mga naguguluhan din dito, no? So, mag-a-apply sila ng exceptional hardship, but at the same time, they are going to prepare the documents intended for the no objection statement, believing that their application will be sent to the Philippine EVP. No. If you are applying for exceptional hardship, the application will be filed directly with USCIS. So this is the application for the 2-year home residency requirement waiver. And then at the same time, you will also apply with the Department of State. Ito yung recommendation for the J1 waiver. So dalawang application yun, concurrent. But yung Department of State will just wait until the time that yung USCIS natapos na sa kanilang pagre-review and they will make a recommendation that, yeah, you deserve to be granted a waiver of your 2-year home residency requirement. So, doon nagtatrabaho yung dalawang departments na yon. So, again, klaruhin ko lang ha, if you're applying for a no objection statement, that application will be filed directly to the EVP. You are still going to submit to the Department of State, but this presentation is not for NOS. This is for the exceptional hardships. I will focus on the exceptional hardship, okay? So, again, the filing process will be both through USCIS, and at the same time, another application will be sent to the Department of State. Minimum requirements. So, when you file for the exceptional hardship, the minimum requirement is that the applicant, in our case, it could also be the qualifying relative, or you could actually ask them to sign both statements. But the general rule is that the applicant should submit a written statement of exceptional hardship on the part of the qualifying relative. So, ulitin ko lang, ano bang mga qualifying relative? The qualifying relatives are those U.S. citizen spouse, or U.S. citizen green card child who are green card holder spouse or children. I'm sorry for that. Okay, so again, U.S. citizen spouse or green card holder spouse or U.S. citizen child or green card holder child could be your qualifying relatives. Then prove exceptional hardship on either relocation or separation. So this is interesting though because I've had talked to a lot of waiver applicants, and part of the conversation kasi is yung economic hardship, no? So some of the clients that we've talked to said, Nick, I don't have economic hardship. So either because ang marami talaga silang pera, or because they are actually well off in terms and they've saved a lot and so on and so forth. And they would tell me that, Nick, I can support my wife. I don't have this hardship. And then you start talking about, sir, this is how the exceptional hardship works. every factor that you're gonna present, and we're gonna talk about those factors, you have to say, you as the qualifying relative will undergo exceptional hardship, either in the case of me, you as the qualifying relocating to the Philippines, or you being separated from your wife or from your spouse for 2 years, kasi uuwi siya, kasi wala na siyang status in the US, and you stay in the United States, right? So, then I tell them that imagine yourself, you are rich, you have the money, you have the saving, but unfortunately, you would want to be with your wife, you're gonna relocate to the Philippines for 2 years. You have no work, you have no access to your funds, and it could be a lot of other factors. And then they said, we don't want to do that because it will be hard for us to see. That's when you fully understand that it's not the question of whether or not you have the money. It's actually the hardship that you will go through once you would relocate to the country kung saan yung spouse mo nakatira. So, but we'll go through that more or less in the next slides. So, ito yung common mistakes that we've seen in other people's exceptional hardship applications. So they believe that if they would be able to actually show one or two of these factors, that they will have a chance of being granted a waiver. So family separation. So it will be extremely hard for me because I will be separated from my wife or from my spouse, right? And the challenges here, though, is the spouse will only be separated from you for 2 years. And time flies very fast. And it is equally difficult kung kakakasal mo lang. So then how are you going now to say it will be exceptionally hard for me to be separated from my husband or from my wife. So a lawyer could actually argue all other factors, economic, the well-being, the safety of the qualifying relative, country conditions, kung may mga civil unrest ba sa country mo, or may mga political unrest ba doon, or may war ba doon, may calamities ba doon, or may mga diseases ba doon. But the lawyer is not in the best position to argue the mental, the psychological, and the emotional hardship that the qualifying relative would experience. So normally, in our cases that we filed, we normally ask the qualifying relative and the non-US citizen spouse to consult with a forensic psychologist because we need them to argue for us the mental, psychological, and the mental, psychological, and the emotional hardship in both cases of relocation and separation. And of course, they have to go through the methodologies, psychological examination questionnaires, and we would receive the report. We're gonna read them and incorporate them in the personal statement that we prepare for our clients then. So economic detriment, what it actually says that, hey, if I am actually earning $30,000 a year in the United States and I'm a high school graduate, then what does that look like if that US citizen spouse or green card holder spouse will go back to the Philippines? How will they get gainful employment? So again, ito yung sinasabi nila na mahihirapan ako maghanap ng trabaho kasi high school graduate lang ako, and then I'm American looking, and so on and so forth. And the Philippines is quite known for being discriminative of people who are of old age or kung wala kang degree. So mahihirapan ka doon. So another example is difficulties of readjusting to the life in a new country. So even in some cases, USCIS or the courts actually said that, hey, if you don't know how to speak Filipino language, then it will be difficult for you to immerse in a new culture. Then it could be argued as exceptionally hard for you. But kung yan lang yung magiging argument mo, then it will not win an exceptional hardship waiver. The quality and availability of education opportunities abroad. So sa US, marami kang options and you could actually get scholarships and all that. And most schools here are actually of better qualities, no? So then you go back to the Philippines, and then the non-US citizen spouse actually live in a remote rural area where they don't have access to quality education. And of course, you would want the best for your child. You would want them to get the best of what's available in your community. However, because of your location, walang options na ganon. Then you present that as your argument. Kung yun lang yung argument mo, it will not win a case. Number 5, inferior quality of medical services and facilities. So when you are actually starting to put in argument that, hey, in my place, the quality of medical facilities are inadequate or actually of poor quality, make sure that you will be ready to respond to a request for evidence because the government will not take that easily. So hanapan ka ng, why did you say this? What's your basis of actually saying that the quality of medical facilities or services in your area is of low quality? So again, be careful with what you say in your personal statement. Ability to pursue a chosen employment abroad. So let's say that your husband, U.S. citizen spouse, is a scientist, right? But then you would want to stay in the rural area. So anong magiging option niya to pursue employment because he would want to actually live with you? So, again, what are we saying then? So, ang sinasabi niya, if you are only using one or two of these factors here as your main argument to get a waiver, chances are you will be denied because these are just common consequences of deportation. So, of course, your visa will expire. You have no choice but go home and live outside the United States. Kung may asawa ka, definitely you will be separated from your spouse. So you will be separated from your family. It will be difficult for you to pay to get to get employment, especially with the pandemic now. Some of you will argue that, hey, I resigned from my work before I actually get my J1 visa, and I will not be able to find work. But the government will just say, but yeah, but you know that already, right? So those are common consequences of deportation. You cannot just use these individually or singly because that not will win a waiver. So then pag-usapan natin kung ano yung mga factors na ginagamit namin to have a stronger argument on an exceptional hardship. Number one, family ties. So, hindi to inclusive of everything that we're gonna use, but these are just examples of the cases that we've used and we've successfully get an approval of exceptional hardship waiver. Babalikan ko yung mga questions natin ha after this. So, family ties. So, here, you would want to present that, hey, my US citizen spouse is the breadwinner of their family, that he or she is taking care of their parents because old age sila and they actually live closely to their parents so they could actually take care of them. They will drive them to the hospital every day and so on and so forth. Then you can use that argument because if you're gonna pull the US citizen spouse and bring that person to the Philippines, who will take care of their oldies? Who will take care of the parents who are sick and who are already aging and so on and so forth? Then you can start now painting the picture of why it is very difficult. But then again, always think one argument or one factor is not enough. You have to correlate it with the other factors, right? So ito yung another example natin, responsibility for the care of any family member. So if your spouse is actually, especially yung mga child custody cases, where your spouse actually had a 50-50% custody with their children, with the other ex-wife or husband, you actually have a very strong argument there because it will be exceptionally hard for you if you live outside the United States and you have 50-50% custody with your minor children and you are actually providing child support to them. Yun, medyo lalakas na ng konti yung iyong argument na yun. Social and cultural impact, fear of persecution or discrimination. So we've actually represented somebody from Indonesia where being a member of the LGBT community will actually put them in danger if they want to go back to the Philippines. So it will be easy for them to actually put that argument because of the persecution or discrimination. Access or lack of to social institution and structure for support. So halimbawa, yung ano namin, yung client namin actually is nasa listahan na siya, waitlisted na siya to be a recipient of a kidney donorship, no? So, kung aalis siya sa United States, then mawawala siya dun sa listahan na yon. So, then you can use that argument that it will be exceptionally difficult for that particular US citizen na mawala sa United States. So, again, sinabi ko kanina, inability to speak the language, pwede mo ring magamit, but then again, you have to correlate that with the other factors. But I will go through more on that example pagdating natin sa ibang factors. The best example of correlating is the economic impact. So, economic from sale of home. Halimbawa, kakabili nyo lang ng bahay. Ngayon, pupunta siya sa Philippines kasi gusto niya kasama ka. Paano yung bahay? Right? So, chances are, baka ma-repossess lang yun. Right? Or we've represented a client whose earning from his business is about $400,000 a year. And then we actually argued that, hey, if you will force this person to live outside the United States, and he is actually managing a realty property firm, then it will be exceptionally hard for them, no? Because you as the owner of that firm needs to personally talk and meet with your clients. So it will be very hard for you just to talk over the phone, over Skype, not to mention the time difference between the Philippines and the United States. So then we successfully were granted an approval on that. Again, ability to recoup losses or repay student loans. So again, not able to pay student loans have a lot of repercussions coming back to the United States. Your credit scores will be bad. Hindi ka man makulong, but at least yung credit score mo magbago. It will be difficult for you to take some loans further kasi babalik after 2 years, babalik ka sa United States. But the worst is if you will not be able to pay child support. So again, going back to the Philippines, you are a high school graduate, you will not be able to find job. How will you be able to pay child support? And then, pagbalik mo dito, meron ka ng warrant of arrest because you could be put in jail by failure to pay child support. Okay. So again, babalik ako dun sa economic hardship mamaya. Health conditions and care. So health conditions and availability of any required medical treatment. So halimbawa, if the person is actually undergoing dialysis or have kidney failures and they live in a place back in the Philippines na walang access to quality facilities. But then again, you have to be able to document why you said the facility is inadequate or of low quality. So again, you could actually go to search indexes of quality conditions per area in the Philippines kasi may mga records namang ganon. May mga alerts din na ini-issue ang US Embassy. So you should be able to find those write-ups to support your argument. So prior trauma suffered by the qualified relative. So may mga cases din na, oh, I've been to the Philippines, I stayed there for 1 month. Then I was hospitalized 5 times or 3 times because they could not bear the heat or because of the mosquito bites or allergies or anuman. So once they have that history or trauma, you could actually use that an argument that, hey, I have this prior experience. If you would force me to go back to the Philippines to live with my wife, chances are I will go through the same experience. And we've done that and we've been approved of that. Country conditions. So again, every month or at least every time that there is a reason for the Department of the U.S. Embassy to issue travel warnings or alerts, they would actually tell you, hey, do not travel to southern Mindanao or do not travel to Zamboanga or any parts of the Philippines. And your client happens or you happen to live in those areas, then you could actually use that as an argument that, hey, you know what? Even the U.S. Embassy is telling us not to go there. So how much more if my U.S. citizen husband or green card holder spouse will be able to live in those places? So then that makes your argument strong. Significant crime, environmental catastrophes like flooding or earthquakes. So even the U.S. Embassy in the Philippines is saying that most victims of calamities and crimes happen to be in the wrong place at the wrong time. So then we actually have a case where USCIS has challenged us to say, why are you saying that why the applicant will be subjected to will be subjected to exceptional hardship when there is actually no history that they were subjected to or exposed to the same crimes. But hey, look, U.S. citizen even said that, U.S. Embassy even said that not all victims not all victims alam nila kung kailan mayroong calamities or mayroong shooting or kung saan man, right? So again, the statement of the U.S. Embassy is correct in saying that most victims of crimes and calamities happen to be in the wrong place at the wrong time. So we've used news reports where foreigners actually just have a vacation in the Philippines, then suddenly they were victims of a stray bullet, right? Or they were actually victims of kidnapping for ransom. Or they were actually shot at a public place. There were one incident in Cebu where a foreigner he actually visited Cebu to marry his fiancée, but he was robbed and killed. So again, these are not planned, and these foreigners doesn't want to be in the wrong place at the wrong time, but those cases happen. So then you could actually use that. There are also crime indexes that you could actually use in the country where you would want to live. So again, you use that as your argument to win an exceptional hardship waiver. So balik tayo doon sa economic hardship. Kasi sinasabi nga natin kanina, na kung isang factor lang ang gagamitin mo, then you will never win a case. Right? Because the principle that applies to that is what we call the totality of circumstance principle. No? Ang ibig sabihin nun, the US the officers handling your case are actually specifically instructed by the rules and regulations that you cannot just use one factor to deny an application. So you have to consider all factors and consequences in their totality and cumulatively. So anong ibig sabihin nun? Totality and cumulatively and common consequences that on their own. So, ang sinasabi nga natin na, di ba, common consequences, itong kanina, babalik lang ako dito, family separation, economic detriment. So, let's take a case where high school graduate lang yung asawa mo, no? So, and they were actually having a very good income in the United States. The problem is, if they will relocate to the Philippines, anong magiging trabaho nila? Right? And they will be staying with you for 2 years. Then suddenly the depression comes in. That's where your forensic psychologist would help you. And then mag-aaway na sila, which actually put in danger the relationship. No? Then magkakasakit na sila. So dadramahin mo ng konti yung exceptional hardship waivers mo. So then, it's not only the economics though. Again, the financial stress and strain that the qualifying relative would undergo going back to the Philippines. Pag wala ka ng pera, doon magsisimula lahat ng problema. So that's basically the basic formula that we use, that hey, if the person, the qualifying relative has no stable source of income, then all the rest will be used as an argument in addition to the economic detriment. No? And it actually works well for us. The other factors that we actually use that has been helping us a lot are country conditions though, no? So again, the Philippines has a very good have a very good history of wars and kidnapping for ransom and foreigners being kidnapped. You could actually use that in your argument that hey, again, you don't have to have an experience where your spouse has been a victim of kidnapping or burglary or a stray bullet for you to be able to argue that he will be subject to the same circumstance, because then again, the US Embassy themselves says that anybody can be in the wrong place at the wrong time and happen to be the victim of crimes and calamities. So, if you decide to do this on your own, trying to find a way, and it is an art to make your statement to combine all these factors. Kasi ang sinasabi niya, pag isa-isa lang, these are common consequences of deportation, and that doesn't grant you an approval of an exceptional hardship waiver. But the moment you're gonna combine all these, and there's a lot of ways you're gonna combine all these factors, then it becomes an exceptionally hard situation. So, ito yung sinasabi niya na totality of circumstance principle. So, the officer, once you put in number 1, number 2, and number 6, then the officer will have no choice but consider all those factors and then weigh whether or not those combination will merit an exceptional hardship situation. Either pag magre-relocate yung US citizen doon sa Philippines o kung saan ka man, or if they choose to stay in the United States and their wives actually go back to the Philippines. Now, the other challenges of the teachers though is because of their program, they will be living in a place separate from their US citizen spouse. No? So we have cases where we were challenged that paano mo nasasabi that it will be exceptionally hard for them to be separated when in fact they are already separated now, right? So let's say for purposes of conversation, the wife is actually living in the Virgin Islands, right? But the husband is living in Pennsylvania. Then why did you say that it will be exceptionally hard for them? So the way we argue that is saying that yes, while it is true that they are temporarily separated, no, but every time that they miss each other or because of an emergency, it is as easy as buying a ticket and 2 hours, 3 hours later they will see each other because they belong in. They are living in either the same territory, or actually it's just easy a matter of just hopping on a plane. It's totally difficult when you are outside the United States without a visa. So in case of emergency, you cannot just buy a ticket, right? You have a visa, you need a visa to be able to come back. And even if you have a visa, then there are May pera ka ba? Pambili ng ticket? O kung may ticket ka ba, available ba siya? Just enough time for you to be able to at least see your loved ones in the times of emergency. So again, if you think about this, and this is the last slide I will be presenting to you though, it is exceptionally hard also to prepare an exceptional waiver. So, if you really need an exceptional waiver, and if you could actually, hindi naman siya masyadong mahal I mean, depending on the lawyer. I would advise that you seek legal advice in preparing your exceptional hardship waivers. But, naintindihan ko kung some of you will not be able to afford a lawyer, just try to again research, marami namang write-ups on what you could actually use in your argument for exceptional hardships. Or you can go back again to this presentation and try to use some of these common factors or consequences and just try to find a way on how you could intertwine or actually use 3 or 4 factors and use that in your argument, because using 1 or 2 as your main argument will not give you, or at least give you the confidence that you will be approved of a waiver. So yun lang yung basically how we prepare waivers. It's an art, So when you write a statement, you have the ability of combining these factors para mas mabigat yung sitwasyon nyo. Then dramahan mo ng konti, because at the end of the day, the purpose of the waiver is to draw out the emotion of the officer to the extent that kaya mo siyang dalhin to your emotions, at kung mapaiyak na siya doon sa sinusulat mo, then chances are you'll be approved. Because again, those are still within the rules that they have to consider all factors that you've presented. Krisha, sagutin ko lang to. Sabay po ba sinasubmit sa iyo ang exceptional hardship? Ma'am, you only submit the main argument to USCIS, but you submit to the Department of State only the DS 3035 and all other elements. So, more or less yung sa Department of State na sinasubmit mo, documentary evidences lang yun. No? So, wala kang argument, you just submit the statement of reason why you are applying for the hardship. Okay, can I still use travel using J1 visa while applying and waiting for the approval of the green card? Yes, ma'am, for as long as your J1 visa is still valid. Pero pag expired na siya, of course, you have to wait for your work and travel permit to be able to go in and out of the United States. Okay, would all these processes be taken care by your team in case we retain you? Yes, ma'am. We handle we make sure that we work closely with the clients to be able to identify factors that we could use for the exceptional hardship. Ryan Hill, for exceptional hardship waiver, after favorable recommendation from the Department of State based on their website, was released the case status. How long will it take you to release? Normally, pag kunwari nakatanggap ka na ng recommendation from the Department of State, normally 1 month, meron ka ng approval ng 612. Recommendation. So there might be delays now with the pandemic, but more or less it should be within that time frame. Sa Marina, question po, just in case po na makausap namin yung employer namin na bigyan kami ng H1B, ang sila, may chance po ba kami na ma-process yun? And when po right time mag-request sa kanila nun? After that po, do we need to seek legal for this matter? Okay, so ma'am, generally speaking, ma'am, pag employment-based petitions, you need a lawyer, right? Unless yung organization mo very well versed yung HR personnel nyo, right? But so far, based on our experience though, the districts that we've talked to, generally hindi nila alam yung other options for teachers other than the J1 visa, no? So then that's why we presented to them the H1B option, cap exemption, and then or the immigrant visa option for some cases na kailangan na talagang umuwi yung mga teachers kasi mag-expire yung visa nila. But to answer your question, right? When is the best time for you to apply for H1B? So it depends kung subject ka the 212E. So kung hindi ka subject for the 2-year home residency requirement and you are now in your beginning of your 3rd year, then I would recommend that you apply for your H1B. H1B can be premium process and it can be approved in 1 month to 2 months. So may H1B ka na nun. So then you don't have to worry about renewing for the next 2 years after the 3rd year mo. Or if you are already in your 4th year or 5th year, at the time approved na yung 2-year extension mo, then you could apply for the H1B as well. So again, do you need legal assistance on that? Again, depends. Most cases, yes. Employers employ immigration lawyers to process employment-based petitions for them. But if your school is well-versed on filing H-1B, kasi yung HR nila is a dedicated person filing for their teachers, then they can do that themselves as well. I hope I answered that question. Okay, so ito na lang, sa Kisha, after submitting po ng document sa DOS, ano po ang next step? So, ma'am, una, dapat ang sinubmit mo is basically the hardship, which is you will need to spend time preparing your exceptional hardship. Once that done, you could either submit the DOS application at the time you filed your exceptional hardship to USCIS, or you could wait after 1 month, 2 months to send the DOS, because at the end of the day, the Department of State will not decide on your application unless the USCIS will actually forward to them a recommendation that you deserve the J1 visa waiver. So the two agencies actually work hand in hand as far as your exceptional hardship application is concerned. Ralim, Attorney, good evening po. This is my second year of teaching here in the US. I obtained my J1 visa in Abu Dhabi, and the US Embassy granted me a 5-year visa without 212E rule. Same din po ba sa... Okay. Ano po pina-safest na year para makapag... So, ma'am, kung 5-year visa ka na, so it means you don't have to renew, right? So, it means if you're going to apply for a no objection statement, the rule required that you have to comply at least 2/3 of the term of your program. So, you have to comply with that. So, in that case, you have to apply after your 3rd year. But if you are not subject to the 212E, then ma'am, you can apply anytime for H-1B or for your green card application, depending on your circumstance. Okay, nag-reply na ako. Okay, so again, if you have questions, that actually ends my presentation. This is a very short presentation, pero umabot pa rin tayo ng almost 1 hour. I hope I was able to give you a glimpse of how exceptional hardships are done. No? So hindi siya yung tipong after your first consultation, you will be able to identify or will be able to actually prepare for exceptional hardship. There are still other factors that you and your lawyer needs to discuss. Or if you want to do this, it could take you time to really understand how the exceptional hardship work. There are examples on the net on how to make arguments, but then again, it could be conflicting, it could be confusing. So again, kung kaya nyo naman, I would recommend that you get the help of an immigration lawyer to help you. Hello, Ma'am Rosemary. Yung mga nabanggit mo po bang factors, exceptional hardship waivers, applicable din po ba sa K1? Ma'am, I don't know why you would need a waiver on a K1. Can you just help? Can you just send me a message then? Because these were hardship here are intended for the J1 visa holders. Okay, namimili lang ako ng mga question dito na sasagutin ko ha. Okay. I think yun lang yung mga tanong, no? So again, if you have time later, you could actually review the presentation and better understand what we've talked about. So again, common consequences to, and then the common factors. Once you can identify some of these factors here, you will have a good chance of getting approved. So good luck and good night. Maraming salamat po.